Canadian Debt Solutions, avoiding the bankruptcy process might be the right thing to do. This blog discusses a very interesting recent decision in the British Columbia bankruptcy case. A licensed insolvency trustee is trained to develop Canadian debt solutions. The case of Mr. Hervias and why sometimes the best advice is that you don't need to go bankrupt. Mr. Hervias made a court application to annul his bankruptcy. He says that the bankruptcy assignment ought not to have been submitted because his only creditor of any significance was the Canada Revenue Agency. The evidence showed that CRA would have accepted a voluntary proposal to settle his debt and regular monthly payments affordable to him. CRA does not challenge an annulment. It is encouraging his proposal to repay the debt. The trustee is the only party to oppose the annulment application. Mr. Hervias had significant equity in buildings he owned with his son and his wife. Mr. Hervias owed CRA, his major creditor, unpaid income tax of $23,820.50, including penalty and interest. In April 2017, CRA froze his only bank account. He sought assistance from a debt consultant, Canada Debt Helpline. On the second meeting with an agent of Canada Debt Helpline, they introduced him to a lit. The trustee met Mr. Hervias at the offices of Canada Debt Helpline. The court determined that Mr. Hervias was presented to the trustee by the debt counselor. The evidence showed that Mr. Hervias looked for the help of a debt consultant, not for a bankruptcy trustee. The court found that at the date of bankruptcy, Mr. Hervias had net equity in real estate of $95,000, far more than the total of his debts. I question whether Mr. Hervias was even insolvent at the date of bankruptcy. His bankruptcy happened because a debt consultant, who had a cozy relationship with a lit, recommended a bankruptcy trustee with whom no doubt a financial relationship existed. I had written before on the evils of the debt consulting/debt settlement industry. At the time of the bankruptcy, Mr. Hervias declared some other little financial obligations including a possible debt of roughly $900 to a recreational vehicle park chain, $213 owed to TELUS Mobility from an old phone agreement, and a $186 debt to Best Buy for a laptop computer that he had not repaid in full. Mr. Hervias had assets that well surpassed his obligations. Notwithstanding, he met the technical interpretation of a bankrupt person under the Bankruptcy and Insolvency Act. The evidence showed that CRA would have agreed to an informal proposal, allowing Mr. Hervias time to repay his debt to CRA. As stated above, his other debts were minor. His bankruptcy was unnecessary. This is a prime example of the dangers of debt consultants and the trustees who are in bed with them. For the record, my firm does not have a relationship with any debt consulting or debt settlement firm. The court determined that it was absurd that someone with considerable assets which created income would assign himself into bankruptcy. This is especially so when the main creditor is prepared to accept payment over a longer time span in amounts that the debtor can afford. The court concluded that these circumstances were both special as well as uncommon. However, just due to the fact that bankruptcy ought not to have taken place, an annulment does not instantly follow. The law is clear that the bankrupt must additionally satisfy the court that in all of the conditions of the case, thinking about all the different stakeholder interests, the discretion needs to be worked out in favor of annulment. The court was critical of the lit. The court found that prior to the assignment in bankruptcy, the trustee should have consulted with CRA. He had done so, he would have found out that an informal proposal was possible. The court annulled the bankruptcy. Mr. Hervias was ordered to pay the trustee's fee and disbursements forthwith, subject to taxation. If you or your company are experiencing financial difficulties, call the Ira Smith team. We always offer a free consultation. There have been numerous times where we have advised debtors that they do not need an insolvency process. Rather, they can avoid it and implement an informal process. We do not earn any fees from such advice, it is just the right thing to do.
I hope you enjoyed the video. The Ira Smith team is available to help you at any time. We offer sound advice and a solid plan for starting over, starting now, so that you'll be well on your way to a debt-free life in no time. For more information on a no-cost basis, please visit our website or call us. Our website and telephone details are coming right up now. Ow.